Bom dia a todos, meu nome é Leonardo Nemer Caldeira Brant, eu presido o Centro de Direito Internacional com sede em Belo Horizonte. É com muita alegria que eu saúdo a todos os presentes, saúdo igualmente os professores internacionais e nacionais que irão estar conosco durante essas 2 semanas, durante o 16º curso de Direito Internacional. Eu gostaria de dizer que, em primeiro lugar, esse curso foi todo desenhado num novo modelo online. Nós já estamos aí no 16º curso desse gênero. Ele foi totalmente adaptado às novas circunstâncias, o que, de certa forma, permitiu também uma extensão do número de participantes, de professores internacionais e nacionais participantes. Temos este ano 19 grandes nomes do direito internacional que estarão presentes conosco durante essas 2 semanas. Num primeiro momento, portanto, eu gostaria de agradecer a todos os professores que colaboraram conosco, que estarão conosco nesse período, com palestras muito interessantes sobre temas dos mais variados do direito internacional. A todos eles, o meu muito obrigado. Em segundo lugar, saúdo e agradeço também aos alunos, aos estudantes que estão participando neste período de julho, conosco durante essas 2 semanas. O nosso também muito obrigado. Esse é um curso que envolve uma grande equipe do Centro de Direito Internacional, a qual eu tenho o imenso orgulho de colaborar e de presidir. Ele é um curso que pretende trazer para o Brasil e para a nossa América Latina o mesmo modelo de cursos que, de forma quase centenária, já é uma tradição nos países europeus e nas principais universidades do mundo. Portanto, para nós uma grande satisfação que tenhamos ele já há mais de uma década no Brasil. O curso de inverno de Direito Internacional, com toda a sua abrangência e extensão, não seria possível de ser realizado igualmente se não fosse a relevante parceria e a confiança e o apoio da Fundação Konrad Adenauer no Brasil. A ela estendo um caloroso agradecimento e tenho a certeza de que estamos contribuindo juntos para os valores do direito internacional, para os valores dos direitos humanos, para os valores do Estado Democrático de Direito, para os valores da democracia e, com certeza, para a compreensão e construção de um mundo, de um universo internacional mais justo e mais equilibrado. Portanto, agradeço de forma calorosa ao apoio da Fundação Konrad Adenauer no Brasil. Gostaria, portanto, de dar início ao 16º curso de inverno de Direito Internacional, esperando que todos tenhamos 2 semanas de muitas atividades e aprendizado. Um forte abraço a todos.
Good afternoon, everyone. My name is Carla Volpini. It's an honor to participate of the 16th International Law Winter Program. I have the great pleasure of introducing Professor Laurent Sermet as today's speaker. For more than 25 years, the studies of Professor Sermet has contributed to the development of human rights, mainly the rights of the indigenous people that until nowadays suffer the reflections of the colonization. His unique approach allows us to comprehend human rights in its plural and significative dimensions. Today, Dr. Sermet is professor at the Institute of Political Studies at the Aix-en-Provence and the Université de la Réunion. The topic of his speech today is Indigenous Peoples' Rights in International and Regional American Law. Professor, it's a huge honor to open this panel. The platform is yours.
Thank you very much. Thank you very much. Hello to everyone. I'm very pleased to introduce this lecture, and I'm very keen to have your question. I think the subject of indigenous people's rights in international law and regional American law is a big subject, a very interesting subject. First of all, I would like to thank Professor Leonardo Brandt for his invitation. I used to come in Belo Horizonte twice. It was a great pleasure for me. And of course, this year, it's much more difficult, even impossible, to join Brazil. So we tried to have this lecture by Zoom. First of all, I would like to say that my English is poor. So sometime I will have to use French, and then the idea will come to my mind. Maybe, Professor, you can help me to translate if necessary. I would like to know if you hear me okay, because the connection is very unstable. Is it okay for you to hear me? Sorry, it's okay. It's okay or it's not? Is it okay? It's okay.
Oh, I'm so sorry. I was on mute. It's okay. We can hear you perfectly. Okay, all right?
Okay, perfect.
I forgot the mute.
It's okay. It's okay. I will begin with a map. I think it's very interesting. Okay, Americas and Amazonia is not the same, but I was in French Guiana 4 months ago, and I met many Aborigines, I met many indigenous people of Amazonia. It was very, very interesting. And by the way, I had this map, and you see mostly 2 colors. The first colors you can see is orange. The second color you can see is green. Orange is about indigenous territories in Amazonia. As you can see, it's a big part of the subcontinent, South subcontinent. You have many indigenous territories, and with it, you have also green, which are protected areas for environmental purpose. And many of those orange and green territories are very nearby. And this lesson, this map gives us a lesson, a very clear lesson. Where you have indigenous territories, you also have environmental protection. Environmental territories, areas for protection. Whatever the law of those 2 territories, indigenous territories, protected environmental areas, are whatever the law is. Of course, we know that there are many, many countries. One of them is Brazil. Of course, here on the map, there is the law of Brazil about indigenous territories, about protected areas for environmental purposes. There is other law in French Guiana, other law in Suriname, of course. All those domestic law will have something in common, a root in international law, a root in international law. Okay, I thought this map was very interesting before the introduction. I turn to the introduction itself, and I would like, first point, to have a discussion with you about contemporary outlook on indigenous people. What does that mean? Not legally, but substantially. When we think, when we try to analyze, to understand what are indigenous people, how do we see them? First answer, I would like to emphasize the enchantment. There is a kind of enchantment due to the cultural difference that show us indigenous people. And there are many, many times, I would say there are many times. In the 19th century, there was the discovery of indigenous people, the discovery of Brazil, of course, before the 19th century. After World War II, after colonization, let's say, there was something else that was the discovery without any or with small colonial purposes. We tried, the Western world tried to understand after World War II, how do those people think? How do those people live? What do those people believe into? And this time, let's say, was a kind of enchantment. The cultural difference as an enchantment. Before, let's say, in the 18th century, when the very first discovery of very far away territories were possible, there was in France, in the legal thinking and philosophical thinking, two myths. The first myth was about the discovery of Tahiti in the middle of the Pacific Ocean. Bougainville arrived in Tahiti and he was totally enchanted about how those people live in peace, peaceful life. And he said, we are bad as Western world because we want their resources, we want their island, we want their wives, and they are good. We are bad. That was the thinking of Bougainville, discovering Tahiti. At the opposite, Diderot emphasized the fact that we introduce scene, Western theme in those areas that Western world was discovering. Okay, this enchantment by the discovery of the cultural difference was between Western and non-Western world. We will learn from each other. It was a very positive thinking. Okay. Then I turn about this cultural difference as an enchantment to a very well-known thinker, an anthropologist, Claude Lévi-Strauss. Claude Lévi-Strauss, very well known about what he wrote, Structural Anthropology, one of these famous books. And he went to Brazil as he was young. He was beginning because there was a special relation between France and Brazil. Brazil asked for France to come and set up a university in Sao Paulo. So he went to Sao Paulo, and due to that, he discovered the indigenous people of the South American continent. Two dates about Claude Lévi-Strauss, 1952 and then 1971. In 1952, he wrote an essay the UNESCO asked him to write, and this essay was known as Race and Histoire, Race and History. It's a French translation of Race et Histoire. And then one of the main conclusions was that there would be something terrible for a indigenous people, indigenous population, that would be to have no contact whatsoever with other people. It would be very bad to be fully isolated. That was his conclusion. This small book, this essay, was very important for the UNESCO philosophy. UNESCO philosophy about cultural relation was, at that time, those people having their cultural signification, their cultural meaning, have to cross, have to meet. That was the original thinking of Claude Lévi-Strauss, 1952, Race et Histoire. Then, 20 years after, 1971, he went back to the UNESCO and gave a lecture 20 years after, 19 years after, and he said, no. This lecture is known as Race and Culture. Previously, it was Race and History. It's now, 1971, Race and Culture. And he said, at the opposite of his previous thinking, that isolation was the solution. In order to preserve small groups, small population, they have to remain isolated because the cultural relation is not neutral. When there is cultural contact, there is a minority, there is a majority, and the majority will impact so much that the minority will be destroyed. And then, in 1971, he said the opposite of what he had said previously. And, of course, it was very difficult for UNESCO mentality, for the UNESCO thinking, political thinking of UNESCO, because he said to UNESCO, you have to change your politics. And then it was a difficult time between UNESCO and Claude Lévi-Strauss. Another lesson of his conference in 1971 was, and this point is so current, is so interesting for us today, he said that the cross-cultural relation is not neutral. The problem is not that we have to respect another culture. No, the problem is demographic. We face worldly a demographic problem. And due to this demographic problem, we have to separate small group. And we have to emphasize on isolation. Okay, I turn now to my second point of the introduction. After cultural difference as an enchantment and the limit of this enchantment, the current life, the real life about indigenous population, indigenous people. What do they face? They face drama, many drama, due to discrimination. Many discrimination, and they try to achieve some resilience. What happened to them? In many times, in many occasions, there are some kind of explicit or implicit extermination. There are some kind of extreme vulnerability, and in many occasions, the right to fight, which is of course recognized, is not possible because they don't have enough force, excuse me, I say it in French, they are not in sufficient position to fight, to really fight about their extreme vulnerability and this extermination. Another point about this drama and this resilience is about the need to protect their identity, physical identity, cultural identity, spiritual identity, and B, they need to be protected in regard to their land. And here, there is a matter, there is a need for law. There is a need for law in order to have some protection, and there is a need for public policy. Interestingly, in this relation between drama and resilience, of course, there is a new legal term, which is the notion of indigenous people. This notion is not very old, and it has been recognized, let's say, since 20, 25, 30 years. Previously, the term was not indigenous people, but was indigenous population, which is very distinct, as we will see. Introduction. Third point about what I have written about the indigenous thing. What do indigenous people learn to us? What they learn to us? What do they give as lesson to we Western world, or modern, if not Western? What do they teach us? They teach, for example, that there is a radical unity between man, culture, and land. Man and land, culture and earth. That we have to respect not only the land, but the earth in itself. Well, they pay so much attention to ecology, environment. And you remember the map I had in the first image. This map shows the link between nature and culture. Okay, they learn us that we have to protect us, that we have a special link that we have to respect. Another lesson that we can hear from indigenous people is about the rejection of modernity, of the speedness we are into. And they criticize the way the modernity is today. I turn now to a third presentation, third page. What definition? And now we turn to a more legal thinking. If we try to have an understanding, how will we define them? And of course, how will international law define them? And here, interestingly, international norms choose not to give any explicit definition. There is no definition. There is no legal definition. As we will see, the 2007 resolution does not give any definition. And of course, it may be difficult to know what we are talking about. Example, is it the same that qualify a population as a minority or as an for its indigenousness? Minority, indigenousness, is it the same? Is it different? Is it partially the same? It's difficult. Okay, indigenous people, indigenous population, and other difficulties, source of difficulty. Okay, I would say that the term of indigenous population is more for cultural purposes, sociological purposes. We identify a population as it is distinct, culturally distinct. This is a population. But today, when we have to compare the term population or people, we choose an international law, choose for indigenous people. Clearly, without difficulties, but if we say indigenous people, it means that the concept is not sociological, is not cultural, but is political. To say it with other words, I would say that. If we are talking about indigenous people, we are talking about self-determination. And indigenous people is qualified as such because it has the right of self-determination. If you choose to speak about indigenous population, you only recognize some cultural features and the right to have the freedom of speech, the freedom of religion, the freedom to live with an identity without the political concept of self-determination. Okay? There are also some vocabulary, some terms that are interesting, such as tribalism or nomadism, for example, and international law is not fully sure. So I recommend that we choose and we use the term of indigenous people, having in mind that we are talking mainly about political self-determination. Another point is about the distinction between, and I will insist on that. I will insist on the difference between indigenous people and indigenous individual. Indigenous people and indigenous individual. I come now to Martinez-Cobo. Martinez-Cobo was a special rapporteur of the UN, and he gave in 1986 a doctrinal definition, a doctrinal approach. He said that in order to understand what are indigenous people, population, is said that there is a link between the past, the present, and the future. In order to understand what we are talking about, legally speaking, there is an experiment of a colonial shock. They were the first inhabitant of a land. That land was colonized. That is the past. Second, there is a link between the past and the present. B, presently, nowadays, they face discrimination. They face vulnerability, and they are not fully free. They are part of a nation, but this nation was imposed to them. And C, there is a link between the present and the future in the sense that they want to preserve their tradition in the future. Martinez-Cobo said to us that if we want to understand the real notion of indigenousness, we have to make this link between the past, the colonial experiment as first inhabitant of a land, then the facing nowadays of discrimination, and the future, the wish to have their own culture, their own language, their own spiritual identities. And what definition? Just a point. We leave the very, as we'll see, consensual approach of South America about indigenous people, and we go to Africa. In Africa, the whole continent in 2006 was opposed to the work of the UN General Assembly. The UN General Assembly has to postpone its work for 1 year, 2006, 2007, due to the African continent. That continent was not in accord, was disagreeing about an international consensus about the fact that indigenous people faced in the past a colonial experiment. And the continent said, we have our own definition of indigenousness. I turn now to this third main point of the introduction. What role for international law? What do we ask to international law in regard to indigenous people? What is the relation between international law and indigenous people? First element of answer, law and international law offers a common language. We saw the map. In this map, we know that there is the law of Brazil in regard to indigenous people living in Brazil, French Guiana, Suriname, and Venezuela, and so on, and so on, and so on. International law has a common language. For example, we had just a little understanding of this common language. People or population? B, of course, the function of international law is to protect. So we wait for a protection by international law. And C and D. I think this point is very important. There is a kind of ambiguity of this international law, because international law is Western thinking, where indigenous people have their own non-Western thinking. And will this Western thinking of the law be in favor of the protection of indigenous people? It's not sure. It's not sure. I turn now, and I finished the introduction about the problematic. I think that there is two problematic, and this problematic is unique. The first element of the problematic is how will international law say about indigenous people's rights? What will the norm be? And you have to be in mind there is a big distinction between soft and hard law. There is the soft law for indigenous people, and there is the hard law. And then how to constrain. Without constraint, we know that the state in which the indigenous people live in is the main force, okay? Okay, the state of France, the state of Brazil, they take commitment to protect, but how do they protect effectively? How to say, how to constrain? Et en français, in French, I would say, comment dire, comment contraindre? Comment dire, comment contraindre? Now I will follow two main paths. First, what are the norms, international law norms in relation to indigenous people? And B, what are the international mechanisms of protection? Very simple. What norm, what protection? This is the plan. Is it okay for the structure? I follow now. Okay, first point. If we pay attention to international laws, we understand that the hard law exists, but is very limited. First, I would quote the Convention on the Right of the Child, 1989. Okay, for the first time, let's say first time, yes, I made a conference about indigenous child 3 or 4 years ago. It was in Canada. For the first time in international human rights law, Article 30 used the term of the minority child and the indigenous child. So it was possible to think about indigenous child in international law. There is also the Convention for the Biological Diversity, 1992. And this convention in the Rio process, was talking about indigenous communities in relation to the knowledge they have in regard to nature. And they can teach us something, how we can preserve and how we can use the biological diversity. But you see here, you have two initiatives. They are very limited. It's one article. The whole Convention of the Right of the Child, the whole Convention of the Biological Diversity is not directed to indigenous issues, not at all. There is two exceptions in international law, in international hard law. The Convention of the ILO, International Labour Organization Convention number 107, adopted in 1957. The whole text is about indigenous population. But this text was ratified by very limited states. So yes, it is hard law, but you have to bear in mind that the number of states is very limited. Interestingly, this text was adopted at the end of formal colonization. Maybe there was also some remote kind of colonization at that time, okay, but the Convention of 1957 was in a colonial or post-colonial context, and it refused to use the term indigenous people and preferred the term of indigenous population. In 1989, Convention 169 made an advancement and chose the whole convention to speak about indigenous people, but same remark, the number of states that have ratified is very limited. Brazil did take the ratification of this treaty. I turn now another kind of international norm is the World Human Rights Charter. The World Human Rights Charter is the UN Declaration of Human Rights, 1948 to begin with. In this text, this fundamental text for international human rights law, is there the mention of indigenousness? No. Is there the mention of minority rights? No. There is something very interesting in the preamble is about the world of the human family. Okay, that's interesting, but this text was adopted in a non-spirit of indigenousness, clearly. Second text, International Covenant of Civil and Political Rights, 1966. Article 27 is very important, but interesting for us, this text rhyme of minority, individual and minority group to have their own cultural differences. But this text was not written for indigenous people. This text was written for minority individual belonging to minority groups. Okay, it's possible to say, to construct something that minority and indigenousness, they gather something, they share something, but the term was not. The term was not. And the third text of this World Human Rights Charter is the Covenant for Economic, Social, and Cultural Rights. No mention at all. No mention at all. So you see, the hard law is very limited. In regards to indigenousness. I turn now to the main text for the main international norm for indigenous people. And this text is extensive. I would say that this text is systematic, but there is a but. It is soft law. This text was adopted by the General Assembly in 2007, the 13th of September 2007. It is the UNDRIP, UN Declaration on the Right of Indigenous People. This text is the text for indigenousness, but it is not a real constraint. This text has said that this text said about indigenousness, but this text is not binding the states. Well, it is not binding, but binding a little. It's very difficult, but it's soft law. It's soft law. Just very clear, because time is running and running fast. Article 3 is about self-determination. Article 3 is about self-determination of indigenous people. Okay, that's it. We have the norm, but it's a soft law norm. And the states at the General Assembly choose not to transform this UN declaration into a UN treaty. They choose. Okay, there are some very interesting clauses, like the right to land. They have a right to access to land, even if they lose this land. But, and I finish with this extensive, but with this recognition, there is a limit. There is a clear limit. And this limit is set up in Article 46. Article 46 is the closing of the recognition of indigenousness. Yes, there is Article 3, right to self-determination, but no, there is no international self-determination. The self-determination remains possible within the existing state. So we understand that there is a clear relation of verticality. The indigenousness recognized via international law has to recognize the prior recognition the existence of the state. The state will remain and will remain as a state. We can say the things with another word. There is no sovereignty. There is no real sovereignty recognized to indigenous people. If there were a kind of sovereignty, indigenous people could become independent and form states. It's not possible. So it means that we have a kind of paradox of international law. Indigenous people are subject of international law, but not in the sense of subject and becoming a state. Okay, so that's the limit, and it's a clear limit. I come now to the declaration of 2016. This is a very interesting point, because the continent of America is, up to today, until today, the single continent that chooses to have its own declaration for indigenousness. And it is not a copy of the 2007 text, which is the UN text. It's an American text. And what me coming from France, where France has a very strict position on indigenousness, it does not exist in the French political thinking, in the French legal thinking of the state, not of the doctrine, but of the state. Indigenousness has not to be recognized. There is a clear standing of negation of indigenousness. In the opposite, what is linked to this declaration, the Declaration of the Right of Indigenous People in America, okay, is that the Americas, North and South, may be analyzed as an indigenous continent. If there is a need, if there is a public policy of international nature, it is because the continent may be characterized as an indigenous continent. There are many, as you see, many clauses, Article 1, 3, the famous Article 3 we have in the 2007 UN Declaration is also here, Article 3 of the American Declaration for the right of indigenous people to self-determination. Okay. Article 11, 12, right to protection against genocide, racism. Okay. It's a very, very interesting text. It remains soft law. It remains soft law. The spirit is not the same. I will maybe insert to this distinction with the question. I turn now and I finish this first point about the real difficulty that the UN faced in the UN diplomacy, how to solve the contradiction between collective and individual rights. That is, you remember I quote the UN Declaration of 1948. This declaration was dedicated to individual rights. And all the treaties choose after, and the two covenants of 1966, they choose to have an individual recognition of the rights. And here, the difficulty is that we do not recognize only the rights of indigenous individual. We recognize collective rights. So the innovation of the 2007 declaration, if it remains a soft law norms, is very important, as it means that we have three kinds of rights in regard to this new saying about indigenousness. First, there is international universal rights at the UN Declaration is stating about. Second, there are individual specific indigenous rights for individual. And then third kind of right, there are some collective indigenous rights. The UN diplomacy decided to have an agreement in the 2007 declaration if and only if there is an addition, collective and individual rights. And would there be collective but not individual rights, there would be a disagreement of the norms, of the spirit of the norm. And this is really difficult, and in many situations it is not possible to solve this contradiction because collective indigenous rights prevail indigenous individual rights. Let's think about the right of a woman, in indigenous situation in comparison of universal and universal thinking and indigenous thinking. Okay. Agreement and disagreement. I turn now point 2 in order to have the time. International protection. How does it work? First, I would like to say that there is a very interesting body of the UN, which is the Permanent Forum on Indigenous Issues. Okay, and I would say that this Permanent Forum is a kind of transnational indigenous parliament because the people that are gathering in the UN are the indigenous people, and these photographs shows us that there is formal and informal, there is modernity and indigenousness in the United Nations buildings. So one of the international protection comes from this permanent forum. I turn now to another kind of protection, soft protection, I would say, the UN Special Rapporteur. Here you have two photographs. One is about this famous Special Rapporteur, José Martinez Corbo. We've talked about his definition in 1986. And this is the present Special Rapporteur, Victoria Tolli Corpus. You have those photographs. Interestingly, what do those UN Special Rapporteurs do? They described, naming, I would say, the protection comes by naming and shaming, naming and having the conscience of a situation. Of course, if we want to have real and deep protection, we have to go to judicial body at international level. One of the body that gives a lot of judgment is the Inter-American Court of Human Rights. The first case was about indigenousness, was about the Awastini versus Nicaragua, 2001. And here you have two photos, one at my links is the territory these people recovered, and on the left, the territory they were asking, and they had to plead in front of the courts. And on the right, you have the photograph of young indigenous girls. Very interesting to understand. This case was about land. Of course, was about land. It was the first case dedicated to these indigenous issues. Okay, what was the conclusion? The conclusion was that, and it's very, very important, we were talking about Western and non-Western legal thinking. First, that indigenous people had developed through history a notion of ownership, of ownership that is not individual but collective. And that's very, very important, because in regard to right to property, in Western thinking, the property is and may be only of individual nature. Here we have collective ownership. The tribe, this population, these people, they own collectively a land, collectively. And that was very interesting that a court recognized the concept of collective ownership. This court did it. Another point of this judgment was about that land is part of the culture. Land is the root of the culture. Land is useful for spiritual life. Land is useful for integrity. Land is useful for identity. And another conclusion of the judgment was that land and the relation to land as not a question, or not only a question of possession, but is a question of identity. Identity between the past, the present, and the future. Conclusion. I did a presentation very, very short, very quick, and of course, methodologically, the question is, what does international law give to the cause of indigenous people? First, I would say indigenousness allows international law to have new concepts. Okay, one of these concepts is about the collective meaning of the rights. Previously, the legal thinking was centered on the concept of individual rights. Another conclusion about the role and the function of international law is about the fact that soft and hard law give their own approach of the right of indigenous people. Of course, one of the difficulty remains not, as I decide to give the plan, not to say, but to constrain. There are a low executability. The weakness of the mechanism of protection is very, very, very clear. It's very clear. And then I would like now to finish with my friend of French Guiana, and you have here on the right, my friend Alexis Tchouka, who is Kalina in the north of French Guiana, and is a leader into the indigenous problem, indigenous fight. And you have near him young indigenous leader who want to fight about their right in the context of French Guiana. And here Alexis gave me this photograph. Thank you very much for your understanding. Carla?
Yeah, can you listen me?
I do, I can.
Okay, Professor, thank you so much for your brilliant lecture and for providing us with your perspective on this topic. It was a very, very interesting lecture that shows us a holistic vision about the indigenous people, identity and protection. Now we have some questions that have been addressed to you. The first, let me see, just a minute. Professor, can you talk about the tension between the traditional concept of development, mostly economic, and the protection of indigenous people rights? How to overcome this tension?
The traditional concept of development and
tensions between
the hearing is not very clear.
Maybe now it's better, I don't know. Okay, the tension between the traditional concept of development and the protection of indigenous people rights. How to overcome this tension, economic and indigenous rights?
If I do understand clearly the question, because the connection is not very, very clear. I would say that the traditional concept of development is a notion that came in the 60s. In the 60s, the state, the African population, for example, maybe mostly all the continent, much previously in South America and previously in Asia, they became independent. And there was at that time a very interesting concept that was the sovereignty on natural resources. The political need at that time, in 1962, it was expressed by a resolution on souveraineté permanente, permanent sovereignty on natural resources. There was a need as a traditional concept of development. There was a national development, okay? National development meant at that time, we want to be independent. We have to build schools, hospitals, roads, and the whole nation will gather this goal. Indigenous people were not part of that. They were living their lives, they had their cultural identity, and they had to share this national goal. In the political understanding of the situation at that time, the possible recognition of indigenousness was not possible. The first prevailing goal was the development of the countries. So we understand that the notion of indigenousness came 40 years after. 40 years after. You had to understand that this goal of national development was not appropriate for indigenous people. This tension, can it be solved? Because this is the question. If I did understood it clearly, this tension was solved by the fact that this self-determination, Article 3 of the resolution of 2007, this self-determination is not only political, but it's also economical, is also social. What does that mean? It means that indigenous people also have the right to have their own economical development. In the 60s, the permanent sovereignty of the newly state on their welfares, on their natural resources, okay? This was for the whole nation, irrespective the recognition of the distinctiveness of indigenous people. And then with the new thinking, with the declaration of 2007, it changed and it allows indigenous people to have their own economical development. That's my answer, and I hope it is what was waited for.
Okay, thank you so much. We have another question. Is it possible compare or draw a parallel between the American and the African human rights on the indigenous people rights, focus on the effective rights? Is it possible draw a parallel and the American and African human rights? We know that we have a lot of violated rights in both of the continents, and we have the regional systems.
Can you repeat the connection?
Okay.
Can you repeat?
Yes. Is it possible draw a parallel? Is it possible compare the American and African human rights on the indigenous people rights? Focus the effective rights. Is it possible to compare?
Yes, it's possible. Yes, it's possible. But the comparison shows us that the American system was very much in favor of indigenousness. He did a lot. And you remember there was a case, a judgment. And this judgment was about Nicaragua. This judgment was very interesting, but it was very interesting, as I said, about the norms. What I call the norm is the language. International law is a language. It has a vocabulary. Okay. It has some reasoning. It is a language. But you need something else that more than the language. You need something else more, something in addition. Its effectiveness is effectiveness. If you have a wonderful judgment, and I think the Awas thingy was a very good judgment. But this judgment, if it remains only a language, it's not enough. The difficulty they face in this case was that the Nicaragua state waited to give execution to the case. It waited for 7 years after the delivery of the judgment. So what you understand is, yes, the American system of protection of the right is very progressive, is forwarding, is going very fast. But one question is about the language. Another question is about the function. And this function is the effectiveness of the protection. And here, a state remains a state. A state remains a state. If he has willingness to give execution, it's okay. If he does not have willingness, despite a famous judgment, a brilliant judgment, the rights are not protected. Okay, this is the American system. We go to Africa. In Africa, there is a system. This system is very interesting. I worked so much on it. But for a very long time, the system was limited to a commission. A commission cannot give judgment. A commission gives. There are some opinion on the rights of indigenous people. But here in Africa, there is a difficulty. The African continent is not fully open to indigenousness. And this is a real difference of mentality. I said with the declaration of 2016 that the Americas, North and South, were characterizing an indigenous continent. And there is, for example, Bolivia, there was a strong commitment, constitutional commitment for indigenousness. Okay, perfect. In Africa, no, it's not the same. In Africa, they choose to have very limited recognition of indigenousness. For example, there is the Maasai in Kenya. For example, there is the Berber in Algeria. It's very limited. There's the Pygmies in Gabon. But they decided either the whole continent is indigenous, and they choose to say no. They choose to say no. Or very limited population are indigenous. And you have to understand, and that was the first question, that for Africa, the need, the use of indigenous concept, of indigenous legal concept was not so important as in the Americas. In the Americas, it was very, very important from the north to the south, from the south to the center to the north. In Africa, no. It was considered as against the notion of the nation. The nation will prevail. The nation is important. Indigenousness is not. You can go to India. It's the same in India. What do you want to have as a prevalence? What do you want to, what do you choose to prevail? The nation or the indigenous population? You choose the nation. You recognize some element of cultural diversity, spiritual diversity, but what remains important is the building of the nation, the building of the nation. So we come to Africa. In Africa, the openness to indigenous thinking is very limited. Then you have a commission. The commission deliver opinion. And the commission in Gambia, in Banjul, said to the African states, okay, you did not respect, you violated the right of, okay. And then, okay, it's an opinion. A judgment is not an opinion. A judgment has to be executed. An opinion is soft law. Okay, they said that, but another opinion, legal opinion, is possible. You go to court. There is two legal opinions: the defendant and the applicant. Okay, there is two legal opinions. Okay, the African Commission delivered an opinion. So it's an opinion. And recently, the system transformed, and there is now a court. But there is an African court. But, okay, not all the African states recognized the competence of this court. And now it's possible only if and only if your state did recognize the competence of the African court. There is, and to finish, there is two cases in Africa about indigenous people. And now two cases have been delivered, two cases. So yes, African continent is step by step going in the same direction, but with reason, with grounds that are very different. So it's possible to compare. It teaches us Many things. Yes, many things.
Okay, Professor, thank you so much.
That's my answer.
Yeah, this was mine question. The first one, it was student's question. The second one, it was mine. Is it possible one more question, the last one? Is it possible? Yeah?
Yeah.
Okay, so how do you think the human rights courts can help to strengthen indigenous rights? Do you think they can help? Okay, do you think they can really help making programmatic transformations into states' internal rights? So the question is about the human rights courts and the strengthness. So the pragmatic transformations, internal, the state transformations. Okay, I think it's about effective.
Okay, so pragmatic transformation and human rights. Yes, I think, and that was a methodological point I tried to give. I come back to the lesson and I say, what can we wait from international law? Law as a language, law as a common language, because we can use the notion of population, peoples, community. If wherever we are, in Brazil, in Africa, in Asia, okay, a common language. I think that international law as a common language for states, for students and professors, for lawyers, is very effective, very effective. And you remember, I did a difference between soft and hard law. I think this language has been very developed in regard to soft law, because soft law has not the same function as hard law. Hard law is protecting. Hard law is protecting. Soft law is promoving. Soft law is promotion, is about promotion. So it's very interesting to understand that we have this huge text, 2007, as promotion, the promotion of the language. The function of international law as execution is poor. I think if we compare those two functions, the language and the protection, we have to understand that the protection remains very weak. So international law is strong by all those mechanisms of saying, having a legal concept, the notion of indigenousness. Yes, in this sense, it is effective. If we try to understand the protection, the execution of the law, then international law is very, very weak. I think you can understand this distinction, this clear distinction in the function of international law. And of course, if we come back to indigenousness is a very recent concept. The concept of the state is very old. The concept of indigenousness is very young. So again, would this concept be older? This concept would have more executability. Unfortunately, we have to realize that international law is or should be composed of the language and the execution. It should be, its integrity should be composed of the language and the execution. And today, up to date, execution remains that the bad remains the weakness of the protection. Is it okay?
Yes. Thank you so much. To close this panel, I would like to thank you again. It was a pleasure and an honor for me, and as well for the students and the Sedin. Thank you so much. Now we can finish.
You,
Thank you.
See
Bye.
you.